Hello, everybody. Let me get my AirPods in. Let some people come in. How's everybody doing? Oh, let me log on over here. Anyway, where's everybody? Oh, shoot. Hold on. Oh, my lordy. Hold on. We're going to have an echo. Oh, shoot. Hold on. Hello? Okay. Oh, my God. Okay. That could have got really bad. It gets a really high pitched sound. I forgot to have it on mute because I've been using this for our dates. And I forget because I have to have it muted and the audio turned all the way down. For some reason, if it's on, it goes like it's interference. It is so loud. And I don't understand why you can't have them both on though. I don't know if they could just be farther apart or not. Anyway. Lurker, hey, Sarah. Oh, you. I was like, wait, did you change the picture? Oh, I love it. I love Sam. You did such a good job with that too. It's so cute. I love it. Hey Cassie. Oh, you'll miss it. Hey Lurker Laura. Hey Paige, what's up? You have to tell me about how it went today. I didn't get to. I hope it went good, Paige. Hey, Summy, it's Turbo, Tennessee, and Time. Oh, Mamma Mia, you made it finally. Wait, that doesn't. I'm sorry if that sounds really bad. Wait, hold on. Let me pull you up over here so I'm not looking over there. Okay, there we go. Oh. All right. I don't need these actually. All right. Rebecca. Okay, good. I was like, I hope that didn't sound like mean because I don't mean it like that. I understand you're on you're in the future and like your time zone is so it's almost like complete opposite of ours basically because not only are you ahead but you're like the opposite time of day. You're like the complete opposite time of day basically. Anyway, hey Jerry Wayne. I love that. That is so cool. You did like a good job putting that on there. Aw. Hey Polly. Oh, thank you, Jerry. Oh, I didn't even read it. I didn't see what that even said. Cuties down. Oh, because I was like looking over here, and it's not that I can't see over here, but it's like I don't know. I could read it, but it's harder. I'm an old lady. Hey Elvin. Okay, guys, we're gonna. I gotta get ready to read this. I try to read it ahead of time, but it's just hard. It's like, first of all, you know how she writes. Well, Sarah Boone wrote basically two letters or whatever you want to call them, two more things she wrote to the judge, right? He responded too. So we're going to go over that. Yeah. So have you guys read it? How many have read it so far? Okay, sweet. So we on? Can I announce what we're going to do, Paige? Oh, really good. That's good. I'm glad it did. Um, Yeah, let me just announce it real quick, because how exciting. So Paige, you guys remember Paige, Shonda's sister. She had she's the Court TV. Is it Court TV or Law and Crime? I feel like they're owned by the same company, but what did how when they went to you, did they say they were Court TV or Law and Crime, Paige? So they are doing a story on, Shonda and Paul and Timothy. I should say Timothy's case. And so they interviewed Paige and today, but it's going to air a week from Sunday, she said. And she's going to come on when it airs, and we're going to watch it here together with her up here on panel watching it as it airs on Court TV. And so we could like kind of talk to her and like almost like behind the scenes, like what it was like, watching what they're saying, and then your perspective on it by, how it went, everything behind the scenes and what you said. And if there's any new questions, I think it'll be really cool. So I'm actually looking forward to that. We get a little behind the scenes as we're watching it. We could be like, ooh, Paige. So I think that's cool. Plus people still had like questions from before, so I'm sure new questions will arise depending on, what is, I don't know. I don't even know who else they're going to interview, but it'll be interesting. I'm so glad that they got a hold of you. Yeah, I know. I'm excited. All right, guys. So, hey, Courtney. So how many of you guys read the Sarah Boone stuff? I'm going to try my best, like I said, to read it. I try to do it ahead of time, but there's two of them. They're both like 20 pages. I think one's a little shorter than the other. I didn't get through them all. I didn't get through it all because it's just, I tried, but we're going to read them. I'm trying to debate which one to read first, because the one is like, so I labeled it 1 and 2 by the time that they were put into the system, because I figured, okay, the first one would have been put in first, right? And they're like the same day, but one's a little bit before the other. So I figured that one must be first. But after reading it, it's like, I don't think it matters which order. Now, the one that was put in first is the one that's like really long and all these like laws and like just like almost like copied stuff that isn't her words and stuff. So we could probably skip some of that. So I might read the other one first, the shorter one. Anyway. All right. So yeah, Scott. CNN. What do you mean, Michelle? How did it feel to be covered on CNN? I don't even know what that means. Explain that, Michelle. I don't know what you mean by that. It's probably just something that went over my head. Yeah, that'll be exciting. And that's awesome that it'll be on Sunday. Sundays are like great days for lives too, Paige. So is Sunday a good day for you too? Oh, thanks, Paige. That's so sweet. I'm glad that I could help. I bet you did good. Yes. Oh, sweet. Okay. Your son? All right. Hey, Rebecca. All right. So let's get into this, guys. Okay. Okay. Oh, that would be really cool, Paige, to hear from you both, as this case is one of those that just stays with me portal to me. Yeah. Hey, Susan, I'm good. How are you? All right. I am going to share my screen and we'll just start her up. Oh, wait, no, you guys didn't answer me. How many people have read it already? Has anybody read it? I always like to know ahead of time. Like I kind of get a good feel of like, just basically put a Put a 1 if you read it and a 2 if you haven't. Okay. It's the newest one, Sally. I think it just came out yesterday. I'm pretty sure yesterday. So if you haven't read it in the last couple days, then you haven't. All right, so okay, a lot of people haven't. All right, cool. Well, it's Sarah stuff, Sarah Boone stuff. All right, let's start it up. I think I'm going to go with the second document first, just because it's a little bit easier and shorter, and start off from the second. Okay. And like I said, the judge did respond. There's a response too, so we'll read that too. All right. Oh, hey, Tennessee, did I say hi to you already? I meant to if I didn't. Hey, Annabelle. Samsonite, you're funny. Samsonite. All right. Hey, Pamela. Rooftop Jitterbug. Happy Wednesday. Yes, I am too. I'm glad you caught it too. All righty. Wait, will you guys just give me 1 minute? I got to put chapstick on. I'm sorry. Just give me 1 minute. 1 minute. Okay. Oh, thank you. All right. Missy B79, Shimmy Dancer, and Scott. All right, let's do this. All right. Are you guys ready? Pull it back up. Here we go. So, the suit, Sarah Boone. She has she's basically requesting some help. I don't know if this is, well, I didn't get to read the response, so I don't know what the judge decides. I skimmed it a little bit and I saw him breaking down stuff, but I don't know. We'll see. Okay, so it's from 7:30 is when it got filed. So that would be yesterday. Yeah. All right. In Circuit Court of the 9th Judicial Circuit, I'm going to skip this here. Okay. Sarah Boone. Temporary motion for reservation of proposed costs to acquire investigator for defendant's defense in trial, which I don't understand because they gave her investigator. Wasn't that the investigator? So I was a little confused about that. But anyway, so it says acquire investigator for defendant's defense in trial. Comes now, Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire investigator for defendant's defense in trial. Investigator TBD. Total amount requesting TBD. What is that to be discussed or something? I know I'm not good with sometimes the little whatever they're called. I can't even get the word for them, but is that what that means, to be discussed, right? Or is there another term in to be determined? Oh, to be determined. Yeah, to be determined. Same kind of thing though. It kind of means the same thing, but you're right, to be determined. Thanks. Yeah, I'm silly. Okay. Okay, so how to calculate unknown by defendant. Reason, no discovery or case materials provided to defendant from the judge. He said he was providing it to you, just you got to have some patience, right? Anyway, this temporary motion is being submitted, meet the delegated due date of 7/22/24 by the judge in the court as stated to the defendant in the order dated 6/28/24. You guys, I'm going to have to make this a little smaller. See, my screen is pretty big. And when I make it too big, it's harder to read for some reason. I know it doesn't make any sense, but it just is. That's why sometimes if I go over here, I could read it better. So I'm just going to make it a little bit smaller so I can read it. But you guys just might not be able to read it as good. And I apologize, but hopefully I'll read it good enough. Okay. The defendant is trying to avoid any further persecution and penalization from the judge and court, while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. The exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court had forced the submittal of this temporary motion. Once the defendant has finally received, she will be able to proceed. Will revise and resubmit this motion upon completion of her review and research of the contents. Do you think somebody's helping her writing these? You know, like with wordings and stuff, which I mean, they're not very good, but do you think she has like a jail law buddy that's helping her with different stuff? Or she probably go to the library or gets books or something, huh? Yeah, right. Wherefore is it therefore? Sarah Boone, pro se indigent defendant, respectfully requests the honorable court to reserve any and all costs proposed to be incurred to acquire investigator for and in the defense of her criminal case for trial. The defendant's requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and representation of self. Conclusion. The temporary motion for reservation of the proposed costs to acquire investigator for defendant's defense and trial should be granted. Oath. Under the authority of Section 92525 Florida statute and State versus Shear, the defendant makes the following oath under penalties of perjury. I declare under penalties of perjury that I have read the foregoing document and the facts and matters stated are true. Certificate of service. I hereby certify that an original of this document has been filed via U.S. mail with the clerk of court of the 9th Judicial Circuit on this 18th day and before the delegated due date by the court of July 22nd, 2024. I further certify that a copy of this original document can be e-served via Florida court's e-filing system to all attorneys and other parties on record. Clerk of Courts Judge Michael Kranick, and then completed and mailed July 18th in the Circuit Court of the Judicial Circuit, Sarah, blah, blah, blah. Temporary motion for reservation of proposed costs to acquire expert witnesses for defendant's defense and trial. Well, I mean, she is going to need expert witnesses. I mean, so she probably doesn't know like how to go about it. I don't know. Is this the proper procedure to get like to be able to go about it? Because she's going to, I mean, this October is not leaving her. That, I mean, that's only in a few months, really. So, I mean, if this is the way she has to go about it, I wouldn't even know. Like, I mean, you'd probably have to ask around, like, okay, I need witnesses. I need this. Like, how am I able to provide this, you know, provide the witnesses with some kind of payment, right? Or how does that work? You know? So, yeah. I don't know how she's going to be ready by October, guys. Anyway, and the judge said she better, like, if it's not going to be put off any further unless she has a darn good reason. Like, I forget the wording he used, but basically there's got to be a really good reason because she can't keep putting it off. But dude, that means like it is only giving her a few months to prepare for a trial that she's not even a lawyer. Like, that's a lot. But she did it to herself. That's what, yeah, I don't feel bad because she did it to herself, but I'm just saying, wow. Okay, so where are we at? Oh, thanks. Oh, you're so sweet. Thank you. She is screwed. No, it was supposed to start. No, that's just a hearing, Sammy Turbo. You talking about the August 5th hearing? I think that's to just the next hearing to, you know, get this trial on its way. It's supposed to be October 7th is the date he gave. So I don't know. Okay, so comes now Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed cause to acquire expert witness for defendant's defense in trial. Oh, hold on. I want to use this. I forgot. There we go. Okay. Expert witness to be determined. Total amount requesting to be determined. How to calculate unknown by defendant. Reason, no discovery or case materials provided to defendant from the judge. This temporary motion is being submitted meet the delegated due date of 7/22/24 by the judge in court as stated to the defendant in the order dated 6/28/24. The defendant is trying to avoid any further persecution and penalization from, this is just repeating for everything, okay, from the judge in court while vigorously attempting to succeed in her forced position of pro se attorney. The exceeded time limit of waiting to receive the defendant's discovery and case materials promised by the court has forced submittal of the, this is just repeating for everything that she needs. Okay, so I'm not going to keep reading it, but let's see what else she's asking for. So the next one she's asking for acquire all witnesses. So temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial. Okay, and it's just basically repeating everything she just did for witnesses. Okay. And then the next one she's wanting for is temporary motion for depositions to be conducted per rule by defendant under pro se attorney, title and position ordered by the judge in court. All right. Judge in court, pro se attorney requests to take deposition for her defense, and no discovery or case materials have been provided to defendants by judge. And then this one might be a little bit different. It states generally at any time after the filing of the charging document, any party may take the deposition upon oral examination of any person authorized by this rule. In any case, no person shall be deposed more than once except by consent of the parties or by order of the court issued on good cause, shown a witness who refuses to obey a duly served subpoena may be adjudged in contempt of the court from which the subpoena issued. The defendant may, without leave of court, take the deposition of any witness listed by the prosecutor as a Category A witness. After receipt by the defendant of the discovery exhibit, the defendant may, withheld leave the court, take the deposition of any unlisted witness who may have information relevant to the offense charged. Oh, thanks, Joanna, for joining. Thank you. Welcome to the family. Family. Okay, so where are we at here? At any time during the course of the proceedings, it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule or with an order issued pursuant to an applicable discovery rule. The court may order the party to comply with a discovery or inspection of the materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed or introducing in evidence the material not disclosed, or enter such other or as it deems just under the circumstances. Willful violation by counsel or a party not represented by counsel. All right, we're not going to read all that. All right. So the next one is, that's it. So that's what she's asking there. But she does do another document. Same day. It's motion requesting immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. So standby counsel to aid and support in preparation of her criminal case for trial. Okay. Comes now Sarah Boone, pro se indigent defendant, respectfully requests from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist and aid the defendant as a whole in the complex, vital procedural preparation with professional guidance during her forfeited right to counsel by the court as pro se attorney and in her proposed lawful representation of self in her criminal case. Defendant's justifiable reasons for requested relief and assistance are as follows. The defendant's sixth constitutional right to counsel is being violated, unlawfully withheld, and forcibly removed from the indigent defendant under false pretenses, speculation, libel, and misconstruction. By the defendant's lawful practice of her entitled first constitutional right to free speech and her God-given right to die? Or wait, to what? I don't know what that, to something. So by writing her experience-derived truth, why can't I, what is this word, guys? Why can't I, because it can't be, it looks like it says die, or, oh, to do so, sorry. God-given right to do so by writing her experience-derived truth and providing red flag exposure in her correspondence to the court requesting needed intervention to avoid present circumstances. She has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance fairly and unrestricted while having the ability to be leveled equally with no prosecution. The defendant is not an officer of this court or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative, lacking requisite professional competency, experience, expertise in one field of law presently and historically. The defendant is defective and ineffective counsel to self as a result, which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with an unprejudiced conclusion of her case. The defendant is presently incarcerated, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks and timely responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically. Her writing just is too much. It's too much. Oh my Lord. By the court rejecting professional, educated, experienced, and the insistence of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney in representation of self. Does she think like talking like this does her any good? Like, it's not, you know? Oh my God, dude, how funny you just said that, because my thing like clicked over to my editing and it was NK. Did you see that, Sarah? Because like, so sometimes if I hit this, it clicked over. Like, it went like this. And look who's there, NK. It did that right when you said that. You're magic. Anyway. Hi, Bushi. Hi, Becky. All right, where are we at? Where am I? Oh, examples of said unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities include the defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24, with only 4 days to submit my demands and motions delegated by the court on before 7/22. The defendant has not reviewed from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24, with only 4 days to submit my demand and motions delegated by the court on before 7/22. The defendant does not have access to computer. The defendant does not have access to the internet. The defendant has extremely limited, irregular access to basic tablets supplied by OCCD. Defendant has access to pay phones for collect calls only, limited to 15 minutes each call. Defendant does not have access to organizational supplies or production equipment, copier, printer, etc. Defendant does not have access to a meeting place for privacy and case review, preparation. Additional daily obstructions and undetermined hardships, disadvantages, difficulties will likely come about due to being incarcerated. And once my case materials are finally received, continued application and reasoning and further lawful support of defendant's request for immediate relief with standby counsel to aid and assist in preparation of her criminal case. In all criminal prosecutions, the accused shall enjoy the right to speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with 2 witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 6. Right to counsel is assured by the 6th Amendment, which has been incorporated into due process clause of the 14th Amendment, as well as state constitutions. So every criminal defendant who faces a potential loss of liberty has access to an attorney who provides effective assistance of counsel at each stage of the criminal proceedings and process. Right to counsel applies whether the defendant can afford to hire a lawyer or not, in which case the court will appoint without charge to defendant. Right to counsel, Bovere Law Dictionary. Thank you, Groovy Canadian Chick. Wow, more word salad. Yeah, right? Oh, thank you, Zavvy Sarah, for all you do. Thank you. Boyfriend just pled guilty. We've all seen a police cam. That's true. Yeah, that's true. But, yeah. Oh, thanks for gifting, Kim. Wyatt, you're just on time. You're just in time. Never late, never late. Just on time, just in time. As long as you're here before the end of the live, you're just in time, because then you could just rewind it if you need. I don't know. Because you're at least you're in time to at least say hi, you know? Yeah, it's a slow night. Where are we at? What is it's Wednesday, okay. Magpie. Alrighty, shoo. Where are we at? Waiver of counsel is criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused. It is made by a person with full capacity unprepared. That is knowing and voluntary forced, and that the clearly and unequivocally rejects representation or assistance by an attorney at law during the pending proceedings. Waiver of counsel. A defendant's decision to waive their right to counsel must not only be competent, but also knowing and voluntary. Maynard versus Boone. The right to waive counsel forced by court is the right knowingly to proceed in ignorance. It is sufficient for purposes of both the state and federal constitutions that the record taken in its entirety shows that the defendant comprehends that a waiver of counsel means that they will proceed into the labyrinth of the law without the assistance of a trained guide. The court must first make inquiry into his competence and be reasonably satisfied of it before accepting the accused's waiver of counsel. Never gave. So she's saying, she never gave it though, right? Yeah, right, Wyatt. I think so. Hey, Heidi. Where are we at? Competence means more than a minimum of mental awareness and capability. However, and involves an intelligent conception of the consequences of his act. No one explained to me. The trial was a farce or a mockery of justice, or was shocking the conscience of the reviewing court, or the purported representation was only perfunctory and bad faith, a sham, a pretense, or without adequate opportunity for conference or preparation. And if ineffective counsel is both a standard of inadequate performance for a lawyer in a criminal representation and a failure of due process of law to the criminal defendant. A person who has suffered a punishment in a criminal proceeding. I was repeatedly lied about by former attorneys to the judge, who is unjustly believing all over me, falsely accusing me of an inappropriate and wrong strategy of removing attorneys who withdraw from my request to the court for intervention, causing me to be forced into losing my right to counsel from their ineffective counsel, to which there is a right to counsel, but who received ineffective assistance, is ordinarily entitled to a new proceeding with adequate representation, as long as there is reasonable probability that the result might have been different if the person had received adequate legal assistance. Ineffective assistance of counsel. Says Beauvier Law, 2012. Due to ineffective assistance of counsel, the federal courts in 1999 set the second sentencing aside. Smith versus Arizona. Florida Constitution 2024 edition. Article 1, Declaration of Rights, Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty and to pursue happiness. Section 4, freedom of speech and press. Every person may speak, write, and publish sentiments in all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. In all criminal prosecutions and civil actions for defamation, the truth may be given in evidence. The matter charged as defamatory is true and was published with good motives, the defendant writing truthful, lawful letters to the court requesting help with dysfunctions of attorneys, then the defendant is unlawfully forced to forfeit her right to counsel from lies, misinterpretations, and ineffectiveness from those former attorneys. Retaliation from the court, the party, defendant shall be exonerated. Oh, she's saying she should be exonerated? Given appointed counsel. Or just from the attorney. Oh, this is confusing. I mean, it's not. I see what she's trying to do. I mean, but it's not going to happen because he did warn her, and well, we'll see. We'll see what his response is. Section 5, right to assemble. The people shall have the right peaceably to assemble without harm, to instruct their representatives, and to a petition for redress of any grievances. Section 9, due process. No person shall be deprived of life, liberty, or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. Section 16, rights of accused. In all criminal prosecutions, the accused shall, upon demand, be informed of the nature and cause of the accusation, and shall be furnished a copy of the charges, and shall have the right to have compulsory process for witnesses, to confront at trial adverse witnesses, to be heard in person by counsel or both, and to have a speedy and public trial by impartial jury in the county where the crime was committed. Section 21, access to courts. The courts shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. Oh, thank you, Carol. Welcome. I'm glad you're here. Hey, Elizabeth. Yeah, it's like, it's just, she's not impressing anybody. And it's just like, I mean, I know she's probably has a bunch of books she's using to help her write for all this legal crap. Like the judge doesn't already know this. Yeah, right. I know. All right. The 14th Amendment to the Federal Constitution declares all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, and property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. The provision has often been construed by the United States Supreme Court, and it has been uniformly held that the due process of law requires ample notice to the accused and sufficient time to secure counsel and prepare for trial. A like rule as to the necessity for due notice and a reasonable opportunity to prepare for a defense is declared in Franklin versus State of South Carolina. Such notice was not a reasonable one, was not due process of law within the 14th Amendment to the Constitution of the United States, and a judgment obtained upon such notice was not binding upon the defendant. The essential elements of due process of law are notice and opportunity to be heard and to defend in the orderly proceeding adapted to the nature of the case. The term due process of law, when applied to judicial proceedings, means a course of legal proceedings according to their rules and principles, which have been established by our jurisprudence for the protection and enforcement of private rights. The accused cannot be deprived of his life, liberty, or property unless by the judgment of his peers or the law of the land. The law of the land, like due process of law, require timely notice and an opportunity to defend. It is vain to give the accused a day in court with no opportunity to prepare for it, or to guarantee him counsel without giving the latter any opportunity to acquaint himself with the facts or law of the case. Every man is presumed innocent, and when accused entitled to a reasonable opportunity to prepare his defense. It is true that great and inexcusable delay in the enforcement of our criminal law is one of the grave evils of our time. The prompt disposition of criminal cases is to be commended and encouraged. But in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense. To do that, it is not to proceed promptly in the claim spirit of the regulated justice, but to go forward with haste of the mob. I mean, here's the thing. I kind of do think if he's going to expect her to represent herself, and then when he says that she only has a few months, I do think he should give her more time if he's going to make her do this. You know what I'm saying? I know she brought it on, but like, she has no legal experience. This is her life. So I do think he should give her more than a few months. I mean, sorry. I mean, maybe you guys might not agree with me, but like, how is she really going to be able to defend herself? First of all, trying to learn the laws and how to, go through the trial properly in a few months where she don't even have the discovery yet. So like, I do think he should give her more time, in my opinion, because that's kind of unreasonable to think that she has any chance of defending herself in a few months. I'm just saying. I know she brought it on herself, but she still has rights, and I don't know. He should just give her more time, in my opinion. But she says that she didn't have years thinking she was going to represent herself, though, is what I'm saying. I mean, you can't even learn it'll take a few months just to learn like the system, on top of it, trying to learn a defense for herself and all the rules and laws and how to, Oh, I agree. She should have, but I mean, what would it hurt just to give her like a year or something to prepare, or however long that would be like appropriate for somebody that has no experience. First of all, she has to learn how to act appropriately in the court, and how to she's not a lawyer. So, and then she has to learn her case and try to get a defense, because everybody's is given that right. You know what I'm saying? All right, so where are we at? An affirmation of the right to aid of counsel is petty offenses, and its denial in the case of crime of the gravest character, where such aid is needed most, is so outrageous and so obviously a perversion of all sense of proportion. Recognizing that the rule was settled at common law, denounced it as not keeping with the rest of the humane treatment of prisoners. For upon what face of reason can the assistance be denied to save the life of a man, which yet is allowed him in prosecution for every petty trespass? How can a judge, whose functions are purely judicial, effectively discharge the obligation of counsel for the accused? He can and should see to it that in the proceedings before the court, the accused shall be dealt with justly and fairly. He cannot investigate the facts, advise and direct the defense, or participate in those necessary conferences between counsel and accused, which sometimes partake of the inviolable character of the confessional. Declared that all criminals shall have the same privileges of witnesses and counsel as their prosecutors. Every person charged with treason, murder, or is that felony, or other capital offense should be admitted to make full defense by counsel learned in law. Notice and hearing are preliminary steps essential to the passing of an enforceable judgment, and that they, together with a legally competent tribunal having jurisdiction of the case, constitute basic elements of the constitutional requirements of due process law. The word of the Webster, so often quoted, that by the law of the land is intended a law which hears before it, condemns judgment without such citation, and opportunity wants all the attributes of a judicial determination. It is a judicial usurpation and suppression, and never be upheld where just is justly administered. Even the intelligent and educated layman has small and sometimes no skill in the science of law. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial and convicted upon incompetent evidence, or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and the knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceeding against him. Without it, though, he may not be guilty. Without it. Against him without it. Though he may not be guilty, he faces the danger of conviction because he does not know how to establish his innocence. If that be true of men of intelligence, how much more true is it of the ignorant? If any case, civil or criminal, a state or federal court were arbitrarily to refuse to hear a party by counsel, it reasonably may not be doubted such a refusal would be a denial of hearing competency. Sorry, you guys, I know I'm not reading this very good. It's hard to read. You guys following it, though? Oh, thank you, Jamie. That's so sweet. Oh, wow. And thanks, Paige. You guys are so sweet. Oh, wow. That makes me feel good. To put the case details through chat GP. That's funny. King Melly. That's a good one. Hey, you never know. Oh, Sally. No. Oh, your eye. Sarah, is your eye okay? What did you poke yourself in the eye with, your finger? Oh, I hope it's okay. Okay, where are we at? Sorry, sometimes I just had to take a break from reading this because it's a mouthful how she writes. It's a mouthful. Hey, Debbie. Okay, pointing to the fact that the right to counsel as secured by the Sixth Amendment relates only to criminal prosecutions, Judge said, but it is equally true that the provision was inserted in the Constitution because the assistance of counsel was recognized as essential to any fair trial of a case against a prisoner. In Ex parte Riggins, a case involving the due process clause of the 14th Amendment, the court said, by way of illustration, that if the state should deprive a person of the benefit of counsel, it wouldn't be due process of law. Judge Cooley refers to the right of a person accused of crime to have counsel as perhaps his most important privilege. And after discussing the development of the law upon the subject, says, with us, it is a universal principle of constitutional law that the prisoner shall be allowed a defense by counsel. The necessity of a counsel was so vital and so imperative that the failure of the trial court to make an effective appointment of counsel was likewise a denial of due process. Within the meaning of the 14th Amendment, all is necessary now to decide. We do decide where the defendant is unable to employ counsel and is incapable of adequately of making his own defense because of ignorance, inexperience, or the like. It is the duty of the court, whether requested or not, to assign counsel for him as a necessary requisite of due process of law, and that duty is not discharged by an arraignment. At such a time or under such circumstances as the preclude the giving of effective aid in the preparation and trial of the case. To hold otherwise would be to ignore the fundamental. I can't make out what that word is already. Something. I don't know. That there are certain. All right, I'm having trouble reading all these words now. Government, wait, blah, blah, blah. I'm going to skip this. Now I'm not going to read all these, like 58, all that. Okay. Yeah, I'm going to skip this too. All right. Yeah, let's skip down. She's just all this law talk. I think we get her point. I want to see the response. Wait, hold on. This one. Okay, here it goes. Wherefore, Sarah Boone, pro se. Did I turn this down already? Oh, yeah, I guess it is. Pro se indigent defendant respectfully requests to the Honorable Court to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. The defendant is requesting collaboration, correct understanding, and overall perspective of and in her extraordinary circumstances by rendering her cognitive incapacities, procedural inabilities, and extreme limited capabilities altogether as fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage, spoliation, what? I don't know, and oppression in her criminal case. Fair and equal position by fair and equal opportunity also be greatly enhanced. The defendant's requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, thrive, and overcome her forced by the court position of pro se attorney and her representation of self. Conclusion. The motion for her immediate relief to defendant by appointing effective standby counsel to aid and support and preparation of her care for trial should be granted. And then she's like, under oath, blah, 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 certificate of service. I hereby certify an original of this document, blah, blah, blah. Okay, let's see the response. Please, somebody else is writing. That was a lot. That was a lot. But let's get to his responses, see what chat's doing. Kim, oh, I thanked you for the gifted membership, right? Thank you again, Groovy. Thank you again for that. All right, so let me unstar that. How's chat doing? How's your eye doing, Sarah? You okay now? Is your pretty eye good? Blah blah blah. Hey Becky G in the house. Yeah. All right, you guys, what are you going to, okay, a question. Let's take a vote. Well, I'm not going to do a poll because there's too many options. But what do you think the judge's what do you think the judge's answer is? Like, how do you think he responds? Do you think he ends up like, I keep like, because I'm so used to having earphones in when I'm doing a live, I keep like thinking they're in, and I keep like going like this, like, because I always have to push them in because they're like always gonna fall out. So I keep going like this and like, oh, I don't have them in my ear because they're not in. I'm silly. Anyway. Hey, Justice Jane. Hey, beautiful mess. Aww. It's still in there. Well, I'm glad your eye is still in there. That's cute. It better be in there. Oh, I'd still love you with one eye. But you do got some pretty eyes. Hey, Shelly Bernie. Number 50. Oh, wait, what do you mean number 50? Are you Sally? All right, you guys ready? Yeah. Oh, Paige. Says, Sarah, I've done that to myself before. It sucks. Sorry, girl. Hugs. I know, that's what I was trying to ask. Well, how did you do that, with your finger or like a pen or a stick? I hope you're not having a stick like oh lordy. All right. Oh, the voice text does not understand my talking. Like, I never use voice text. If I'm going to do a voice text, I just do a voice message, because like it doesn't pick it up, and then you have to like edit it, and it's just like it doesn't, I don't think I pronunciate words that much that it's like all the time editing. I might as well just text it. But some people I think it works good because a lot of people use it. It's just, for me, I just think the way I talk, it doesn't pick it up good enough. So it's just not worth it. But like, I feel like most people do use it. So I guess I could learn to pronunciate my words better if I'm talking. But yeah, I just type it or voice message. But anyway, oh, thanks, Becky. Oh no, Sarah, your eyeglass thing. I should have thought of that. Oh, I'm sorry. That's you might even have like a red scratch on it. Like, have you ever had your eyeball scratched? I have, where it's like a red little scratch, and then it feels like it hurts. I don't know. And then it almost feels like there's something in it when you have it scratched. Thanks, Becky. Wow, 2 of them, Becky. Thank you so much. Yeah, the text. It's funny how, and then the autocorrect. Oh my God, some of the autocorrect. Anyway, what? Oh, how did you get hot wax on it? I think I understood what you said. Like, you got hot wax on your eye, right? Oh my God. I can't even imagine. How do you even do that? Let me guess, you blew out a candle and it came up. Is that how you did it? Like blowing it out and it came up in your eye? I could see that. I got to hear the answer. Is that the wax got in your eye? I have actually in college blew out a candle, not in my eye, but got all over like everything because we weren't allowed to burn candles in the dorms. And the RA was knocking on the door and like I hurry up and blew out the candle and the wax just like flew out. But okay. Oh, okay. Ah, I see. Okay. You could tell me. I'll listen to the long story. You could tell me later. But that makes sense. Oh, I'm glad your eye is okay. Or I'm glad the wax didn't burn it off. Oh no, I'm so like an idiot. Um, oh yeah, yeah. Like scratches almost feel like there's something in your eye, you know? Oh my god. Wow. Oh my lord. How did they end up having to get it out? Oh my wow. Oh, wow. That's did they like take like a how did they get it off your eye? Just did they took it like can you imagine like it like peeling off like oh oh okay, so let's you guys ready to hear the responses? Okay, so I'm gonna do there's a couple responses. Well, there's one that just gives the service. So let me do hold on, let me just bring them all up and then which one's first? So this is 7:30, 4:30. Okay, hold on 1 second. 341. I'll do it in the order that it was filed. So this one's first. All right, 1 second. I think there's one more. $205. Okay. All right. No, that's for 729. So I'm going to do this first. So this was filed 729. So this would have been this isn't his response, but I just want to go through it real quick. So this was the day before she sent this. So this is the day before. Well, it'd be the day before it was filed, I guess. So he does like a order setting hearing. So a hearing is scheduled on August 5th at 8:45 p.m., which hopefully they'll have that so we can watch it. Okay. Premises. Okay. Scheduling a deadline regarding production of states exhibits and defendants exhibits. Scheduling a conference for defendants to view all states exhibits in courtroom 12A. Scheduling a deadline for receiving defendants' objections to state exhibits, scheduling a conference for the state to view all of defendants' exhibits, scheduling a deadline for receiving states' objections, a deadline regarding production of states' witnesses list and defendants' witness list, deadline for receiving defendants' objections, receiving objections defendants' list, temporary motion for reservation of proposed costs to acquire investigator for defendant, defense and trial dated July 18th, 2024. Received July 29th. Temporary motion for reservation of proposed costs to acquire expert witness. Temporary motion for relief. Okay. Okay, so that's that. Then here is Justice Administrative Commission's response to motion seeking due process costs. So this is for the costs. It says, comes now the Justice Administrative Commission by through an undersigned attorney files this response to the above cited motion as follows. The defendant is seeking authorization for various due process costs as follows. Appointment of standby counsel to assist the defendant, costs to take depositions, an unspecified amount for a defense investigator, unspecified expert witness to assist the defense, costs for unspecified witness to appear at trial. As an initial concern, any future requests for due process costs, such as requests for transcripts, investigative costs, or experts, need to be served on JAC prior to the court considering the matter. The defendant is responsible for providing JAC with any motions for due process costs so that JAC can respond accordingly to those requests. JAC may only pay for due process costs pursuant to section blah, blah, blah. As directed by section the General Appropriations Act, all due process services are subject to the Florida statutes and the JAC contract, policies and procedures. Standby counsel. As for the appointment of standby counsel, the court entered an order on June 28th, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on the issue of appointed counsel. Denied, so she got denied about that. Wow. Deposition-related cost. As for costs to take deposition, the defendant is authorized to incur costs to take depositions for those depositions authorized under the Florida Rules of Criminal Procedures. The notice of taking deposition substitutes for a court order of purposes of the court reporter seeking compensation for appearance fees. Wait. Substitutes for a court order for purposes of the court reporter seeking, I don't know. As for the service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. The sheriff must be used to serve in county law enforcement. As for transcripts, JAC has no objection to regular paid rates. The motion in order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing, date of any type of hearing, and recording type and date of recording. The defendant should only order those transcripts necessary for defense of the case. The uniform statewide rates are set forth in the General Appropriations Act. Court reporting services cannot exceed these rates. Private investigators' costs. Pursuant to uniform state rates, the rates for investigators cannot exceed $50 per hour. As required by Florida law, any private investigator providing services in Florida must have a Class C license from the Department of Agriculture and Consumer Services and be employed by an investigation agency with a Class A license. If the court grants the motion, the order needs to indicate the amount authorized for the defense investigator. Based on the docket, it appears Prison Break Investigations, Billy Lane, remember that's the guy that was there on that last hearing, may have already been appointed to this matter. JAC does not object to the court authorizing $5,000 for a defense investigator and $500 for the investigator to obtain case-related documents and materials on behalf of the defendant. So he's giving them $5,000 and $500, but they already did appoint that Billy Lane. So, but it does look like she could go with somebody else. Is that what you guys are taking too? Hi, Donna. Good. I get in a couple weeks. I found a dentist. I did a research and I found one, called, got prices, and picked the best one that I felt. So yeah, I got an appointment for if it's a filling, but for cleaning, I have to wait till the first of the year, but they'll take me for like any issues. So yeah, for the 14th. Thank you for asking. Hi, H Rivers. I don't think I said hi to you yet. Oh, it's just me. You're just in time. Hi, Morgan Lunsford. Yeah, it seems really good pay, doesn't it? But that's the problem. You have to get you have to find the jobs, and you have to like build a name for like courts to appoint. You know what I'm saying? But okay, so based on JAC's records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. JAC does not object to the court continuing this authorization now that the defendant is representing herself. So wow, $3,000 at a rate. Okay. So so how many hours does that give you? Hold on, I want to see something. So I just wonder, does that count as like the time if they have to have them in court, like those hours too? Well, I guess that would be the main time. Well, no, they would have to do. Well, I want to see something. I just want to do a little calculation. So if we're doing so they'd be able to work 15 hours, but that's if they charge $200 per hour. Like, do all of them charge that much? That's a lot. Dang it. I bet for an expert. As to other requests for experts, the defendant will need to file an appropriate motion delineating, I can't say that word, but don't make fun of me, the following: identity or type of expert, motion, the expert services, 3 rate authorized for the expert service. Okay, so the identity or type expert. Well, how many can they do? Hold on. The defendant will need to file an appropriate motion. So 3. The defendant has the burden to show the particularized need for each expert witness. The defendant needs to show the services of the expert is necessary for the defense of the case. So wait, are you guys thinking are you guys getting that she could have 3? Is that what that's saying? Wait. And 3 rate authorized. I don't know. As enunciated by the Florida Supreme Court, a party seeking due process has the burden to establish the particularized need for the due process, prejudice arising from the denial of due process. The determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and that the denial of the expert assistance would result in a fundamentally unfair trial. See, like, for her not knowing how to do this, that's going to be hard because she's not a lawyer. Like, she's going to need to like prove this stuff. Man, she's in for a rude awakening, man. Like, dang it. This is going to be very interesting. I'm almost wondering if she's just going to end up, I don't know. She doesn't seem like the type to just give in and just like, okay, I'm guilty. She's going to fight to the last. Yeah, she will. This is going to be really interesting, guys. So when the judge puts a stop to her strategy of it, doesn't show her in a good light, she's going to, yeah. So 15 hours. Anyway, the cost ordinary witnesses. The defendant will need to submit a more detailed motion. How do you say that word, guys? Hold on. Let me see. Delineating the witness she seeks to summon for trial and anticipated costs. What does JAC stand for, too? I don't know what that is. JAC. Does anybody know what JAC stands for? Hold on. Because they used it up there, too. I want to see. JAC. 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 I'm sure, though, it's because... No clue. Yeah, me either. Yay, your eye is good. Is your eye good? I'm sure. Your eye's really good. I'm silly, but no, I'm glad you're better. I'm glad you're better. I'm glad your eye's better. Don't poke it anymore. Make sure you put the glasses in the right... all right, hold on a second, guys. I'm looking up something. Give me 1 minute. I don't know what JAC stands for. Oh, well, it's not a big deal. Oh, is that what it is? Justice Administration Commission? Okay. Wait, somebody else says Judicial Appointments Commission. Are you guys just guessing? Oh, you did it too. Okay. Cool. So 2 people, Wyatt. Oh, wait, you guys both. No, Wyatt and Sarah have the same thing. Tanya, you have something different. I'm gonna. So you guys have almost the same thing, but one has judicial, one has justice. Huh. I don't know. Oh, that's funny. I was reading the same. Sarah, that's what I was just reading that what you sent me, but I was reading it before you sent it to me. I looked up what Justice Administration Commission and I read it. And then you sent it, and I was like, yep, that's what I just said, but I was on mute, so you didn't hear me. See, great minds. I was like, well, let me look up what Justice Administration Commission. And then when I read what it was on mute, I was like, yep, it's justice, because that makes sense. But you guys didn't hear me, but thanks. Yes. Oh, my lordy. Thanks, though. Thank you. Thank you. All right. Justice Administration, but Commission. Alrighty. Anyway. Yeah, that's it actually. That was all. That was all. What do you guys think? So, I mean, I wouldn't be mad if they gave her more time. I mean, if not, she doesn't stand a chance. And I just wonder if she's going to be able to appeal it somehow, because is there somewhere in there where she's rattling off all these laws? You know what I'm saying? Somewhere in there where she'll be able to get like some kind of appeal because of some of this reason she was given. You know, I just wonder, like, now that it like sunk in and she sees what she's up against, like, wonder if they could just give her one more chance with a lawyer. Therefore, like, she can't appeal or whatever. Because I mean, she doesn't have. I don't know. I just feel like this case is going to be a mess. If she goes through with it, like, I just feel like it's always going to be in. It's just never going to be finalized, because I could be wrong. I mean, but I don't think she'll let it down. She's just going to keep fighting it. Even after, she'll just keep fighting and try to. She's just too persistent. I don't know, guys, but it's going to be entertaining regardless for us. But I don't even know what to expect. Like, oh my God, this is going to be crazy, guys. Her up there trying to have a trial and be her own lawyer. Like, oh my God, this is going to be so entertaining. Best trial of the year, I tell ya. Oh, Silverleaf, how have you been? Okay. I don't know. Well, because she's not a lawyer. So I was thinking for her to like learn how the even the, the laws and stuff. That's what I was thinking. Like, because sometimes like a lawyer needs like sometimes a year's not even enough. They're like, oh my, you know what I'm saying? And she only has a few months and she's not even a lawyer. I know it's her case, but like supposedly she hasn't had the discovery or had all the things, but she should know. I mean, she was there. I don't think I don't know what kind of defense is she kind of try to say? Like, oh, she fell asleep. Oh, he wanted in there. I mean, I don't understand where she could go with this, because I don't think it's not. I don't feel like for this charge to go through, they don't have to say that it was intent to kill. It's just negligence. What she did made him die, and she you know what I'm saying? So it's not like she meant to kill him. But they don't need to prove she meant to kill him. You know what I'm saying? Is it's second degree? What's her charge? Hold on, let me bring up her charge again. Exactly. I think we did. What was it, like 10 or 25 years was the typical? Yeah. So it's like, yeah, she could argue it wasn't intentionally, but they don't need to prove intent for this. You know what I'm saying? It's not. So I don't know where she's gonna go. Why she should have just asked for some kind of deal. Like, was that ever on the table, or she's just so stubborn that she just never even nothing ever? Nope, she never even got that far. Because that was her best bet. It would have saved like the court time and money. She could have got like a deal where maybe didn't get the max that you would get, and because she's gonna get it if she goes through this. It's just. Oh yeah, look at the you guys, the thumbnail. Sarah did the thumbnail for me. Go look at that. Look at her name tag. I almost forgot about that. How awesome is that? Go look at the thumbnail and the name tag that she put on there for Sarah. Sarah, are you here? Here, let me pull it up. Hold on a second. I'll show you. Hold on one second. Share. Okay. Look, so Sarah made the thumbnail for me. Look, isn't it awesome? Hold on. Non-intentional. Dear Judge. That's so good. Oh my lordy. Yeah. Yeah. Legal ignorance. Yeah. But I mean, not for the crime. Like legal ignorance. What do you mean, Shelley? Hiding yourself crazy. Yeah, I'm going to look that up. I think we looked it up when we were going through the Sarah stuff earlier this year. Hold on. I'll look it up in a minute. Hold on one second. Let's look it up. Let's look it up. Okay. I'm itchy. Okay, I'm looking up her charges. I always forget. Like we looked it up before. Hold on, charges. Okay, second degree murder. Oh, here, let me share my screen. Hold on one second. Oh, hey, Tori. All right, you guys, here, when you just Google it, so second degree murder, and hold on one second. Let me see. So second degree murder, hold on, let's look up. We looked up the laws last time. Second degree murder for the death. Hold on, let me look up. Let me do one more thing. Second degree murder. So she's in Florida. Second. Okay, so here we go. So if you look up just like overview, like AI overview. Second degree murder in Florida is the unlawful killing of a person with malice, a forethought, or with a specific intent to kill. It is first degree felony that's punishable by law up to prison. Okay. Wait, so it does have a. I thought it didn't have to be intent. So maybe I'm wrong. Why did I think that you didn't have to prove intent? because you could still get it, I thought. Let me see. The mandatory minimum sentence is 10 years if the defendant has no prior felony convictions. Now, she has those domestic, those would be felonies, right? Those domestic, was it domestic assault? I have to go back to her past charges. They could be, I guess, misdemeanor, but they could be felonies. I'm not sure. With, other abuse of George. But it says a minimum sentence is 10 years in prison if the defendant has no prior felony convictions. But it's 25 if a firearm was used, which it wasn't. The surrounding circumstances of the crime can also affect the sentence. So, here we go. Let's see. To prove second-degree murder, a prosecutor must show that the defendant acted without regard for human life, lacked premeditation or planning, harbored enmity, say that. I'm sorry, I can't say every word. Wait, hold on. I want to read that again. No, acted without regard for human life. Definitely, you could prove that. You could prove that she didn't intend to kill him, but she did act without regard for his life. I mean, the fact that she kept him in there and he's begging to get out, like maybe she was planning on, I don't know. I mean, she could have intended, but I don't think she intended to kill him. I really don't. But she did act without regard for human life, lack premeditation or planning. Had an ongoing interaction or relationship with the victim. So yeah, you don't have to, does that not, I'm looking at that. You don't have to prove that she intended to kill. You just have to prove that she acted without regard for human life, right? So I think, what is going to be her defense? Because that non-intentional is just not going to do it. Because the fact that he's begging to get out, she didn't let him out. Yeah, maybe she could be like, well, I just fell asleep. I didn't mean to. I forgot he was in there. You pass out drunk. Maybe you didn't really mean to. I'm not saying I believe that, but even if that defense, but that's still not enough. That's still not enough. You acted without regard for human life. I'm sorry. That was his life. He's begging to get out. Being actively opposed or hostile to someone. So I looked up, hold on. Enmity. So it's enmity. Enmity. So enmity is, where'd it go? Enmity is what that says, right? Enmity. So harbor enmity toward the victim, which is intense hostility. She did. Think about what she was freaking, she was mad. It was like paybacks. This is for choking me. This is for cheating on me. Enmity, hold on. Enmity, hostility, animosity, hatred, concealed, implies strong open enmity that shows itself in attacks or aggression. So yeah, I think what can she say? You have that video. He was in there. He's begging, he's saying he can't breathe. You freaking acted without regard for his life, saying he can't breathe. You had hostility towards him. You were so mad. She has nothing. She has absolutely no defense. No wonder why none of the freaking everybody's guaranteed that right, but no wonder why nobody really wants to take her case. It's crazy. So yeah, so she could probably get. Now let's look up that law a little bit better, because this is just saying minimum. So they're saying minimum 10 years if you have no prior felony and 25 years. Now they're still saying the minimum is 25 if you used a firearm. So she didn't use a firearm. So maybe 10 years, but I think she does have a felony. So I want to know some specifics. So if you have a felony, what is that? What does that take the minimum up? I wonder. I think it just depends. Let's see. I don't know if depraved mind, when a person is killed without premeditation. The murder happens as a result of imminently dangerous act to another, demonstrating a depraved mind and displaying no regard for human life. There you go. Right there. We'll look it up, Wyatt. I have the, well, at least for Orange County, I have it up. We could just type in, I brought it. Yeah, we'll look her up. I want to get her birthday just to make sure I get all the right ones. Hold on one second. But yeah, we'll do that in 1 minute. But yeah, 100%. She doesn't, I mean, I don't know what defense she could really have, because she's already admitted that she knew he was in there. You know what I'm saying? Like, you can't say, oh, I didn't know he was in there. I mean, what can you, there's absolutely nothing. You know? Yeah. I still, though, I don't think she meant to kill him. I think she meant to hurt him, but I don't think she meant to kill him. That's just my opinion. I think she meant to hurt him, keep him in there, and I do think she probably passed out longer than what she thought. She's drunk and she just passed out and had no regard for his life, didn't care, just passed out, didn't even think twice, which right there, that's enough. And then just woke up and was like, whoa, oh, he's still in there. But I mean, that's still second degree. I'm sorry. You have no regard for his life. I just don't think she wanted him to die. I think she wanted just to hurt and punish him, but she should have thought of that. You know what I'm saying? Like, he can't breathe. I really don't think that she wanted him to die, at least for the consequences more. I mean, I don't know if she cared about his life that much, because look what you know what I'm saying? But like, because she didn't want to, have that, her life, go to prison for the rest of her life. But she's screwed. Yeah, she's pretty much screwed. What is the best one to look up? Because they're like they all go to like specific. I just want to see the punishments. The maximum punishment for attempted second. Oh, attempted. Well, what if you did it? Like, that is it just attempted? Hold on. Wait, when they say attempted, does that mean the person doesn't end up dying? What? I don't understand. Hold on. Let me go back. Depraved mind without regard for human life. Yeah. The second degree murder when the killing lacked premeditation or planning, which it did, but the defendant acted with enmity. Yeah, it's the same thing, basically. Toward the victim, it had ongoing interaction or a relationship. Unlike first degree murder, second degree murder does not necessarily require proof of the defendant's intent to kill. Second degree murder, yeah, does not require proof of the defendant's intent to kill. Let's see here. Where can I bring up like the actual like Florida law? Hold on a second. Isn't there like some website where it's not some like what do you call it, like attorney's page, or did I say hi to you, Don, already? Hey, Al. Hey, Tori, Shelly, Alice. She beat him up, put him in the suitcase, pushed him down the stairs. She may not have wanted to kill him, but she sure wanted her. Yes. Oh, I agree. And she just wasn't thinking like no regard for his life. So I don't think she wanted him to die. She wanted to hurt him really bad, but I don't think she wanted him to die because of the repercussions. You know what I'm saying? What is it on my bed? Oh, that's, you know what that is. So what I want to, why I want it is I want to try to find like what is the max she could get. Oh, I'm going to look up her record too. Hold on one second. Hey, Colleen. Hey, Shradha Niche. Is that how you say it? Yay, you caught alive. Shradha Niche. Is that how you say it? Hey, zavgirl. Sorry, I kind of just blabbering. Hello to you. No, you're fine. Blabbering is good. I like a good chat. Messin Penosa, Tanya. Where's Messin Penosa? She is. Yeah, I would. Hey, Avidi. I feel like I probably say your name different every time. Evade. All right. Oh, Becky, I said thanks to you twice, right? Thanks for each thing. I hope I did, Becky G. All right, so let me look up her record, but I want to find the Florida law, like specific. Hold on, let's do Florida law. There has to be a website. Florida U.S. state, maybe. Okay, let's see. All right, statute. Okay, here we go. Sentences: murder, 3rd degree, 2nd degree. All right. Oh, there's all these different statutes. What statute is it though? Hold on. Whoa. There's so many different like things you gotta like. Oh, this looks blurry. That's weird because it's not blurry on my computer. But like if it's like wow. Yeah, I think our best, easiest way is just to like type it in, like just Google it. I think it's going to give us a good. So, Florida law, second, I'm going to do it one more time. Degree, maximum. I want to see the maximum. So, minimum is 10 years. Okay, maximum is 20. No, it's just giving the. Okay, so it does say. Oh, look. The maximum punishment for 2nd degree murder in Florida is life in prison. So you can get life for 2nd degree, but judges are required to sentence convicted individuals to a minimum of 16.75 years. Yeah, but then why is the minimum 10 years without felony? Is that, but you're required for 16.75? This is other penalties include up to $10,000 fines and life on probation. Huh. So, yeah. So, I mean, basically, it looks like she's looking at, I would say, like, yeah, probably, I guess, 15 years to life. Do you guys think she'll get life? I don't. Well, I don't know. Who knows? Okay, mandatory minimum sentence for certain reoffenders. Yeah. All right. I think we got a good kind of idea. Life is the max. 10 is the minimum, but it looks like Florida, they're acting like you're required to do 16.75 for the minimum. But I don't think she would be acceptable for the minimum of 10 because I do think she has felonies. So we're going to go look up a record now. 1 second. I think they're the felonies. I know you can have some of those could be misdemeanors, but I don't know. I don't know why I think hers weren't. But let's see. 1 second. Come on. I just had it. Okay, here we go. What is her birthday? Just so I want to make sure when I do. Well, hold on. I want to see something. I'll look it up. Oh, actually, I could look it up because the other charges. That's right. The February. No. Wow, there's another Sarah Boone. It's like a. All right, I'm just gonna go by her other one. One second, guys. I'm just going to go under her records where I get the other stuff for the murder and see what birthday's listed. And then I'll know that the rest that's that birthday is that. All right. So where is that? Kranick. So her birthday is 10. Oh, that's right. It's a day before mine. Mine's 10/11. Hers is 10/10. Oh, man. She's a Libra. Dang it. Dang it. There's 10/10/77. Okay. So she has yeah, she has other felonies. So has one other felony. I shouldn't say other. She has one other felony from 2018. It was that one that we have the I think the body cam. It's where is it? Here, I'll share. Why am I not sharing my screen? Sorry. Battery strangulation. Yeah, that was a felony. So she has one felony from 2018, that incident with her and George. So yeah. So they're going to have to determine, it's only one, but it's a violent one, which, usually when it's a violent felony like that, it holds more weight, right? So yeah, she's not going to get the minimum for sure because of that. So if for some reason that 16.75 is the way Florida does their minimum, then she's going to, then she'll probably at least get 20 or more. But like with her representing herself, she might get life because, it all matters. That's what sometimes I get confused, guys. Do we have any lawyers in the house or like anybody that can help me out with this? So you know how sometimes there's a certain sentence. Sometimes the jury has more like say on what it is, the judge. So for instance, if she gets found guilty, then the judge just picks the sentence, right? Like it has nothing to do with the jury. Because I'm just wondering, like, I think she's going to be found guilty regardless. So does it really matter how she represents herself? Because in the end, the judge is going to, well, I guess it could make a difference on how the judge sentences her. But I think the facts of the case are the facts. And the only way she could possibly win is if there's like a good sneaky lawyer that could find some loophole or find something that could like, it would be have to almost be like a lie or something. You know what I'm saying? But isn't there sometimes where the jury does that though? I feel like there's sometimes it could be set up where the jury picks it, right? I don't know. I feel like there was that one case. What was it? And we talked about it. It was one case because not many. I feel like a lot of the times it's just like a set amount or the judge does it. But there was that one case where the jury did it. So I was like, okay, so it can be. What was it? Hold on a second. Let's just look it up though. Hold on. Yeah, okay. I don't know why people were saying that, but I don't remember ever seeing that. I know people said that like a few months ago when I was covering it. When we were going through like the body cams in the files, somebody said that. And I've never heard of a deal. I don't know. Do they? Okay. Well then dang it. Shoot. She's really screwed herself then because the jury's gonna hate her. You know what I'm saying? Like if she just kept her lawyer and then was able to have, her sit back, not run her mouth, let them talk. I mean, still, they're gonna see the body cam, but I don't know. So how are you guys doing? I don't know. It's gonna be interesting, but ain't it cool? Yeah, I never heard it either, but there's some people that are saying it. Like I think it's probably like a couple of people that started that, and then now it's like people are like taking it as real because people were saying it in my live chat like a couple months ago, and I think that's where it's spreading. But I don't, unless if they saw it somewhere. I've never seen it. So I was like, if you could find where you saw that, we tried to look it up. I couldn't find anything where it said deal, but I do want to look up. Let's see, Florida sentence. Wait. Let me see. I'm just Googling that about the sentence. See if it says a judge sentenced some convicted, because I basically asked who picks the sentence for second degree murder in Florida. Just Google AI overview. This is how they answered. A judge sentences someone convicted of second degree murder in Florida. The sentence procedure for second degree murder depends on circumstances of the crime in the defendant record. So it's saying the judge does. The judge will consider the circumstances of the crime, such as whether a firearm was used. The judge will consider any factors that may increase or decrease the sentence. Okay. If the defendant has no prior felony convictions, the mandatory minimum sentence is 10 years in prison. But we know she does have one felony, and it's a violent one, strangulation. The judge may consider the defendant's intent to kill, such as their mental state at the time of the crime. The sentence for second degree murder can range from 10 years in prison to life in prison, plus life on probation and a $10,000 fine. So it looks like the judge does, guys. So basically, the jury will find her guilty or innocent. If she's guilty, the judge picks the sentence. It looks like is what they're saying. So, which is, I think, is a lot of the times it is like that. I feel, but I swear there was that one case. What was it that we talked about in the channel that the jury actually was able to pick the specific sentence? And there's more than one case, I'm sure, but I'm just saying, like, there's this one case that sticks out because maybe it was the only trial that I covered that it was like that or something. I don't know. Does anybody remember or know? Each state is different. Well, can anybody think it is going to be a circus, Shroud and Nietzsche? Can anybody think of a case? Oh, you're saying Chad Daybell's the case where I didn't watch that though. I actually didn't watch the Chad Daybell. That was recently. So you're saying the jury picked a sentence for Chad Daybell? Okay. Is that what you're saying? Okay. Thank you. That makes sense. Okay. Maybe that, yeah. And then the judge has the ultimate say. That's probably how a lot of them do it, I bet. Like the jury will do recommendations and then the judge is the ultimate. So maybe that's why they say the judge does, because he does ultimately, he doesn't have to probably listen in most, well, in a lot of states. I'm sure it's like that, where I'm sure he takes it into consideration and it matters what the jury wants, but he can also make his own decision, I bet. Okay. Okay. So wonder if it was a case in Texas I'm thinking of. Okay. Well, then it was probably more than one. I don't know. Maybe I'm being silly here. Yeah. I think if she could, I mean, she's something else, but I think like, no, I mean, I do think she is like a controlling. I mean, I would never want to be in a relationship with her type. You know what I'm saying? So I'm just trying to think like, if my whole point was, I'm trying to think like, if she didn't drink anymore, would she still be as dangerous? But I feel like potentially she would, even without drinking, because she has this like psychoness where it's like she has to be right. She won't give up. And that, drinking or not, I feel like that could still probably be dangerous, because I feel like she would still be like that without drinking, because we could see, and that's not, I don't know. I mean, I don't know if she would kill somebody again, but I mean, of course, like, she's an alcoholic, so I mean, if she would get out, I'm sure that's probably one of the first things that she would do. I mean, who knows? I know, Wyatt, right? Yeah. Yeah. Oh, I'm not saying it is an excuse, but it could be a factor. You know, it can make people do things that they wouldn't normally do. Not that it makes it better. It means that they have it in them, but that pulls it out of them to actually act on stuff that they might not normally. But it's not an excuse. It never is. It's just drugs or alcohol is always a part of the story. There's no excuse. I mean, everything is a part, you know what I'm saying? It's just a part of your life. So you can't use it as an excuse. Mental illness, drugs, alcohol, trauma, like it's always a big reason for who we are and how we act and how we relate and how we react. But it's not an excuse. You know what I'm saying? We all have to do better, and we all have our little things that we have to go through. So, but some people just can't handle it like others, you know? Some people can't, and it's not an excuse, but it's a part, it could be part of a reason why. It still could be a reason and not an excuse. You know what I'm saying? It's very tricky because it's like the word excuse could be like, you know what I'm saying? Like you can say, oh, it's the reason, you know, like there's reasons why people do what they do. They're not excuses, but they're reasons why they like they're able to do what they do. It's just tricky because it's all about wording and how you look at it. But if you look at it deeper, it's like we're all human and we're all like made up of these different things, and there's limits and there's reason, you know what I'm saying? And it's just, I don't know how to explain it, but yeah. Yeah, I don't know. Evie. Oh, I know, Michelle. I just wish I knew how to, like, I've been working on that for years, trying to be able to like put that in words and explain it in a way where it like makes sense. So no, I hope you didn't think I was coming at you either. But anytime like some of that comes up, I like to try to like get not practice, but try to like explain it. Cause that's like a big part of how I like to break down and view cases and stuff is understanding why, and I love that, like, because my love or my passion was like psychology, and I went to school for it, and I never got to use it. Like, I never got in the field to have a job in the field, and I tried, but they all need experience before you can get experience, and just then I got sidetracked into the pharmacy job, and then I got too deep into the drugs, and here I am. But I feel like I like how I could just use that for the true crime, because it's a huge part of like studying people, understanding people, why. I want to know the why. And it like fascinates me for some reason. I don't know if that's the right word, but like my whole life it's just like, well, why? Well, like why does somebody behave like this? Why do they act this way? Can we treat it? Can we help them? Is there something like deep down that we could figure out or help, or can we get to the root of it or the bottom of it? And I know there's some people you can't help. I mean, there's some people it doesn't matter. They're gonna repeat, or they're gonna do what they're gonna do, but we can still understand why. And I like to understand that, like psychopaths, for instance. I mean, I guess you're not gonna really understand their way of thinking, but just to learn about how they think and how they can operate. And there are psychopaths that just they're not all murderers, obviously they're not all murderers, but some of them are able to like kind of channel their ways into like other things, or like crimes of passion, or like jealousy, or like people that repeat the cycle, like a lot of trauma or drugs, or I don't know, it's just interesting how people behave different. You guys, I almost got all my stuff for the new studio. I got my camera, microphone. I'm just waiting on my computer now. I got my desk put together. I put that together last week all by myself. And it's like an L-shaped one. So I got my mic, my camera, but I don't have anything up because I'm waiting on my computer. So I hope I'm excited to get it all up and running. What else did I get? Computer, mic, camera. I guess that's it. I'm going to take this chair over there because this is the chair. I like this chair. It's comfortable. Oh, I got the shelves that Sarah got me, these shelves. So I don't know. I have to like decorate. Like, so behind me, I'll be able to put my plaque behind me. Some other stuff. I don't know. So they'll have like so basically in my new studio, the desk is going to be where like the wall will be behind me, enough space where I could have like a shelf with stuff behind me, you know, and I'm excited. Wow, good job, Scott. I'm 7. October will be 7, right? I'm always like a year. I'm always like saying, okay, is it 7, 6, 8? I'm pretty sure 7, 7. But that's October. Wait, hold on. Dang it. That's actually a good sign when you can't remember the exact date. And I used to always remember the exact October what, and I can't remember. But that's good, right? That I don't remember. I don't know, October something. I wonder if I have it written down. Why am I thinking 16th? But I might be wrong. Anyway. Oh, maybe Christine. I do want to do a giveaway, guys. I could just do it now. Like I have some of those. Can you see them? Oh my God. I'm thinking if I move, the camera will move, but never mind. Oh my God. I had a stupid moment. Like the camera's connected to my head or something. I was trying to like move, like you can see what I'm seeing, but you can't. I was trying to move it over so like the camera moved over and you can see it over there, but never mind. Oh my God. I'm silly sometimes. But anyway, because I have some of those hoodies, right? It's like if the camera moved over just a little bit, you'd be able to see it right there. Oh my Lord, I'm silly. Oh, Eve, thank you to my name E plus. Oh wait, E plus V E V. I'm sorry, justice to my name. Okay. Oh, so it's Evive? Okay. Evive. Am I doing it good? Wait, are you flicking me off? I'm just joking there, your picture. Evive. Thank you for explaining it. Did I say it right then? Evive? Oh, hi, Sarah Bartley. Hey, Miss Pinoza. Yes. Sarah's actually helping me with some, because I'm not a good, I love my colors, but I'm not good at like like decorate, and you know what I'm saying, like I could pick out things, but like to put it together and stuff, I don't know. She's helping though, and there's yeah, and course colors. Oh yeah, there'll be colors. I have a boom stand, and it has lights in it, like it's I haven't tried it, but it has like a light strip, and I think they actually like go different colors, so that like one of these stands for my mic, so that'll be cool. um the camera, I hope I like the camera, just like a webcam, you know, for streaming, you know. It's not like, you know, like when people do like they get like the portable vlogs, they spend like thousands of dollars. It's just like a webcam, so which is good. If you get a like streaming webcam, they're really not, even though a really good one, you don't have to spend that much money on it, which is really good. So yeah, but I never tried this brand, so I hope I like it. Worst comes to worst, I could just take this one over there. But I wanted to be able to have 2 setups. Like I wanted to still have this if I wanted to record, you know, this camera. So yeah. Wait, I said it wrong? Evie. Oh, it's just Evie? Wait. Oh, because you have the V at the end though. Oh, I see what you're doing. I didn't understand. See, I thought you were saying, look, thanks for the super chat. I thought you were doing E plus VEEV, Evive. That's what I thought you were saying. But you're just saying E plus V, Eve. I see. I misread how you were writing that out. Okay, Eve. That's even easier. Wait, it's just Eve? Really? Yeah. Okay. Eve. Okay. I got it. I got it now. No, I don't think it's Evie. I think it's Eve. It's just Eve. Eve, right? Eve? Yeah, Adam and Eve. Yeah, we can't pronounce. That's funny. But give us some slack. Look how it's spelled. Like for us over here, that would be like Yvette. You know what I'm saying? Like we're not used to it. But Eve, I got it now. I just was misunderstanding when you're explaining it. You're explaining it and then saying it. I thought all of it was how you guys say it. You know what I'm saying? But I got it now. That's simple. Eve. Eve. Oh, yay. Wow. Betty Jo Anderson. So you're sober. How many years does that make? Wow. 17. So wait. So 17 years? Is that right? Wow. Good job. Congrats. For real. Eve. Oh, good night, Sally. Hi, Christy. Hey, Melanie. Christine. Yeah, pretty much. Yeah, that's what I said. I laughed at your joke. I said, yeah, Adam and Eve. Because when you said religious, that I was like, that was a good one. It's like, yeah, duh, Adam and Eve. Pull up some Irish names and prepare to be. Oh yeah, Brooklyn Pisola. Oh, thanks, Casey. So yeah. Oh, okay. Wait a minute, then, Eve. I don't think you understand how StreamYard does it. Thank you for reminding me. Now it makes sense. Hold on 1 second. I got to explain something. Now I see why you're like, how can I know that? Hold on a second. Hold on. Can I show you something? Duh, you probably think I'm an idiot. Okay. Eve, are you still here? We did this before. Okay, I'm on StreamYard. I hope you're here because now I feel like an idiot. So I'm on StreamYard. Can I show you what it shows on StreamYard? Why? Because you're probably so confused. So StreamYard doesn't take the symbols. It has letters. So I'm so glad that, Tanya, I'm so glad that you freaking pointed that out. Okay, let me share my screen. Eve, are you here? I hope you didn't leave because you probably think I'm the biggest idiot. Okay, watch. No, I know, Eve. Well, can I show you something? Can I show you? Hold on. Look. Oh, wait, I shared the wrong screen. Oh, it's too small. You're not going to be able to see. Oh, wait, hold on. Look how it pops for me. Can you see that? EVEDE. So on StreamYard, it doesn't put the flag. It puts up symbols. It puts up letters. Do you see what I was reading? So for me, since I don't go on YouTube side, I'm on StreamYard because I need to be able to share my screen and put up the names. So for me, I'm seeing EVEDE. That's why I couldn't say your name. So I just thought, oh, you must pronounce. When you were just explaining it, I didn't catch on until Tanya just said that DE is the symbol. Well, I can't tell which ones is the symbols and which isn't. You know what I'm saying? So StreamYard, when you guys have a symbol in it, it doesn't pick it up and it'll use letters. So I'm seeing EVEDE. And that's why I kept saying EVEDE. You probably thought I was the biggest idiot. Of course, if it was EVE, I would have known Eve in any second. Like the Eve. I know EVE, but it's EVEDE because that flag. Yeah. Can you see that I'm sharing the screen? You can see, right? Look, EVEDE. That's what I've been seeing. I'm so glad Tanya pointed that out because you would have left tonight thinking I'm the biggest idiot because of course EVE is Eve. Like I would have known that, but I didn't know Eveti. Wait, that's me. I need to make sure when I'm like not when I'm having trouble pronouncing a name, I should always go over on the YouTube and make sure that it's not a symbol that's putting in weird letters. Because I bet you so many people are thinking I'm idiots because I've probably done that to a lot of people. That's one thing I should write StreamYard, because they're always updating. They need to update the symbols because I mean, look, it's ridiculous. Yeah, because look. Oh, yeah. So look, I used to sit Eve for Wyatt. I used to call him Wyatt Rye Swayus. And he's like, finally it came out that he's like Swayus, because that US is American flag on YouTube side, but for me I'm seeing Swayus. So I would call him Swayus, and somehow one night it came out like, why are you calling me Swayus? I was like, what do you mean? It says Swayus. And then we found out that no, the US flag is US. So DE is the Denmark. That's why it's DE. So it doesn't do the symbols. It does like, it has like the letters for it, whatever. US, the flags that'll have the abbreviations. So we found out it's Wyatt Rye Sway. But yeah, oh my Lord. Oh, it's Germany. Okay. DE. I thought she said Denmark. What did Titania say? Whatever, but it doesn't matter. Germany. But yeah, so there we go. Let's see. Anybody else's name? Does anybody here have, let's just get it all out so I know. Does anybody else have symbols in their name? Because then I've been pronouncing your name wrong. Let me know. And I'll see what your real name is now that we have them up. Anybody else have like a flag, or even if it's not a flag, if it's like, I feel like any symbol, it will not come up on a name. So, anybody else? Okay. Thank you, David or Eve. God, Eve. God, I wish that DE, why can't it just do the symbol? Oh, you do? So your symbol comes up. Or wait, what is your symbol really at? Hold on. Is that what it is? Hold on. Oh, wow. That symbol actually comes up on StreamYard, the circle. Well, wonder why some do and some don't. Who else has one? Miss L has one? Yeah, but hers is actually coming up. Maybe they don't have an abbreviation letter. Who else? Oh, Casey Marie. No, yours comes up too. I guess the owls, it's just the flags maybe then. Well, why can they do like an owl and not a freaking flag? So I guess maybe it is just the flag. Who else has a flag? Messina. Well, anyway, I'm glad we figured it out, Eve. I'm not an idiot. Now I wonder why. Oh my God, you had to have thought I was the biggest freaking idiot. Wow. You were probably ready to be like, I don't think I should be watching this girl if she can't even pronounce Eve. Tanya, I am so glad you saw that. Because Eve would have just thought I was the biggest idiot. You guys all would have, because you guys are all seeing the flag, right? I'm the only one not, because I'm on StreamYard. Wow. Well, I'm glad we figured it out. So I guess it's just the flags. Who else has a symbol? Well, let me see something. Anybody else have a flag symbol? Well, mods, if you hear me, any of my mods or anybody hear me say like a name wrong, that's like, you could tell I'm like seeing it wrong, like email me because it could be the flag in the future. Oh my God. Wait, if you put up, wait, what? Oh, you're silly. Or the internet yeah. Yeah, because I feel like, wait, in Danish, Denmark is Denmark. Okay. Um, oh, all right, guys. I am going to end it. I'm going to end it, guys. All right, bye, guys. Thank you, everybody. That was fun. I will see you when I see you. Well, yeah, I'm working on the other cases. I will continue the NK, and then I gotta get the Ezra stuff, and we'll be good to go. All right, bye, guys.